Welcome to the August 26th, 2020 meeting of the Town of Southampton Conservation Board. In accordance with the Governor's Executive Order 202.1, all of the board's meetings will be held remotely via video conference until further notice. So we ask the public to continually check the town's website for updates and new information. The link to participate in this meeting via Zoom can be found on the town's website. This meeting is also being live streamed on the town's website. If you do not wish to speak at the live meeting, but you would like to submit comments for the public record, the link to submit comments can also be found on the town's website. Board members who must recuse themselves from any application will state so on the record and will be removed from the meeting until the end of the discussion and vote on the application. Also, as a reminder, we ask that applicants and their agents please state their name and address for the record. I would invite everyone to join for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Now we'll do a roll call as you've been accustomed to doing. Harry Ludlow, and I'll call each of your names. Michael.
Here.
And Jerry.
Yeah.
And Sunshine.
Here.
And we're going to begin the public hearing portion. At this point, before we begin that, Charlie, you can let in Mike Walsh. And I think, oh, here we go. Tom is here. Good.
Harry, once Tom is here, we can accept the minutes of August 12th, but
Yes.
right now I'd have to abstain from that.
Yes, we can, let's do that first. I just want to make sure we have all the players in here that should be in here for the public hearing.
Can you hear me, Harry?
Yes.
I had a hell of a time getting in.
All right.
And my screen shows 9 people only. I can't show anything more than that. So is there anybody else on?
I have 9 people as well.
Mike Walsh, president, accounted for.
Rank and serial number.
Okay, good. And is Bruce also on?
He should be.
Use now.
Okay, good. Welcome,
See-
Bruce and Mike.
Ann coming in and Bruce coming in.
Ann is coming in?
I see her name, just no video.
Okay.
She's coming. She's coming.
Nice haircut, Bruce.
Thank you.
So if I did Zoom on my desktop computer, would I get more than 9 slots?
Oh yeah, you get a lot
Sir,
more.
you would.
You get a lot more than doing it on your Etch-a-Sketch.
I need to use the iPad for the camera. Would it work if I use the camera, the iPad like it is here, and then also on the computer for the more people?
You could do both, I think.
I know
I don't
Apple's
think you-
splitting
I don't
4
think you
ways
could do
tomorrow,
it.
but Apple
You can't
products
do
are
a
terrible.
computer and a iPad. You do a phone and a computer, but
Oh, you can't log in with both?
well, you could try, but I don't think it's gonna work.
No.
Yeah, I don't want to short circuit somebody. Okay, tell me when everybody's on because I can't see. And when they are, we'll accept the minutes and then open the public hearing.
Ann disappeared. She didn't get in. I see Bruce, Michael.
Yeah, everyone except Ed.
And Charles, on the town website right now, it still shows a live button with the trustees
Yeah,
work session.
it's rebooting.
Oh, okay.
We've been having problems with that too, so
Okay.
My son is doing that, and I'm at home. But I have the recording, so it will go up.
Dan's trying to get back in.
And it's here.
Where is George not coming tonight?
I have not heard from other board members.
There's Ann.
Okay. Guess you can proceed.
Okay, is there a motion to accept the August 12th, 2020 minutes as written or amended?
So moved.
Second.
All in favor? Harry, aye. Michael?
Aye.
Jerry?
Same.
Sunshine?
Aye.
Tom?
Aye.
And Ann?
Aye.
Public hearings, A 180573, Jennifer A. Miller, Elizabeth M. Trapp, and Erica L. Ozu as trustees of the Theodore J. Sider Irrevocable Trust.
Mr. Chairman, I have to recuse myself on this application, but Sean Cambridge, Assistant Town Attorney, is here to cover that. So I will log out and then I'll log back in when the public hearing is over.
Thank you.
And we can proceed on that. I understand it's already an open public hearing.
Okay, Michael, do you want to bring us up to date? It's been a while since we heard from you.
Yes, Mr. Chairman, the last time we were before your board was February 26th of this year. And the matter was then adjourned to April 2020, this pandemic situation. So that's why we're here today, in August. When we last met, we spent a lot of time reviewing this issue of the ACOD that was issued back in 2006. Excuse me, strike that, 2005, as a result of a charge that was filed against Mr. Cedar, the owner of the lot, my client, in 2002, June of 2002. And the gist of it was that in 2002, when that charge was brought, there was no flagging evidence, no evidence in the record of the town's files or anywhere else that there was any wetlands on this property, more specifically the wetlands that are causing us the problem, which is this wetlands pocket on the street side of the lot, consisting of what we contend is a man-made hole that resulted from the mining of clay historically, and there's a lot of evidence in the record that speaks to that. The point of discussing that ACOD was to point out that although the town had brought charges, they didn't move forward, and it's our contention is because unfortunately there wasn't enough evidence on the town side before Judge DeMayo back in 2005 when the case was ACOD'd to show that there was indeed wetlands at this location. That being said, Mr. Sider then applied for a letter of no jurisdiction. He obtained a letter of no jurisdiction from the DEC. He applied for one before your board. It was then determined that the better way to proceed without prejudice to Mr. Sider was to file an application with your board, which we did. He's been at this in various forms since 2002. It's almost 18 years at this point. What we've come around to is an application that complies with the code. And when I say that complies with the code, when Bruce and I were last before you, Bruce was able to show that if you apply the average setback, average buffered standard of 325.9B of the wetlands code, 325-9D, and Bruce can give you the measurements and the specifics. The plan that was filed with you in December of 2019, at the end of last year, complies with that average buffer requirement. The average buffer here, as Bruce will tell you, is in excess of 125 feet when you average the buffer out. That's our plan. That's the plan that as it stands today before your board. We have not changed that plan. We haven't modified it. We don't believe that we should. We believe that we should have obtained an LNJ at the earliest time when we applied for the LNJ. Why is that? There's a lot of evidence in your record, including a recent test hole boring and photographic evidence and 2 affidavits of experts. One is a trained biologist, Bruce Anderson. You're well familiar with him. He's appeared before you dozens, if not many dozens of times. And Sean Barron used to be a town employee. He's in the business of digging test holes, analyzing soils. We've got affidavits and photographic evidence that indeed the holes that exist on this property are the result of man-made activities, namely the mining of clay. There's no evidence whatsoever in the record that would support the assertion of your chief environmental analyst, Mr. Shea, that there is a vernal pond on this property or a woodland hollow. We discussed that at the last hearing as well. We put in the lack of definitions in the code, and Bruce spoke to that as well. There's just no evidence. There's no wetlands plants. There's no wetlands vegetation. There's no vernal pond at this location. It's simply a series of holes that were dug in the site, lined with clay. There's, if you look at the affidavit of Sean Barron, there's photographs that show the clay. There's shards of pottery in the bottom of the hole, a result of human activity, clearly. It's our position that this plan, although it was filed without prejudice, and we believe we should have gotten an LNJ at the outset, that this plan, as it stands, is approvable by your board. We received an email from Mr. Shea with yet more revisions that I spoke to my client about, which are unacceptable. It would basically turn a 2-car garage into a 1-car garage. It would impose a 10-foot side yard setback, sending us to the zoning board and causing not only an aberration in the neighborhood by development of this parcel, by squeezing all the development up against the property line of Ted Cedar and Mrs. Cedar's homestead right next door, but it would be an aberration in the neighborhood. It would be inconsistent with the zoning plan, inconsistent with the pattern of development, and it would severely affect the value of the lot. So our plan, which we presented to you, we believe complies, as Bruce will tell you, with the average buffer rule that you apply over and over in this situation. We believe it complies. We stand by that plan, and we'd like that to be approved by your board this evening or as soon as possible.
Thank you, Mike.
Mr. Anderson's online.
Yes, can you hear me?
Yes, do you want to add something?
Well, I just want to go over and explain to you what the plan is. I hope you have it in front of you. It is a survey prepared by Squires, Holden, Weisenbacher, and Smith. It is dated November 27th, 2019. It features a proposed dwelling that occupies 1,812 square feet, the proposed attached garage, which equals 480 square feet, a 20 by 40 foot swimming pool, and an area of proposed decking that equals 736 square feet. The setbacks, the structural setbacks between the house and we'll call it the excavated wetland hole, which is midpoint of the property as you head south and straddles the property line, is 101 feet, and that's to the deck. And then the other hole, freshwater wetland boundary, okay, off the rear of the property, is 157 square feet, 157 linear feet from the edge of the pool. So the structural setbacks would be 101 plus 157, which equals 258. If you take that and divide by 2, you're more than 125 feet, which allows this board, it fits quite nicely into the standards. The standards for permit issuance are set forth in 339. And we believe we comply with those standards because we do delineate a specific buffer zone. There are no, it is compatible with the purpose. The maximum practical buffer zone sufficient to preserve and protect these two aberrations, which your record shows, is provided in the plan. All reasonable mitigation measures have been taken, and that's not going to diminish. These holes will remain as they exist today forever. Now, if you go to 339D, it speaks to for projects that do not satisfy the standards enumerated. And when I talk about those standards, I'm talking about 125-foot structural setback from a wetland on an undeveloped or otherwise vacant lot. So here you have the structures totaling 125 feet. You have a septic system, which is 178 feet from the midpoint, we'll call it the hole that straddles the property line to the east, and more than 200 feet from the wetland that's found off the rear property line. So the septic system exceeds the minimum setback, and the structural setbacks comply. You should know that the sanitary system proposed here is an IA system. The salt water, the pool would be salt water and contain all the filtration and treatment systems that the town prefers. We're quite willing and able to comply with the drainage requirements of the town. The test hole indicates groundwater to be 20 feet below the grade of the site. So we have no groundwater issues. And it would be located 20 feet off the house would be 20 feet off the side lot line and 36 feet off the front lot line, so it complies with zoning. You should also know that during the, if I go back to December's hearing of 2019, there was an effort by your own town attorney to settle it. Under that settlement, it was suggested that we relocate the driveway so that we could come straight off the road into the garage rather than what was preferred by the client, which is to come off the road and enter through the side. That meaning that the garage door would have faced the side lot line rather than the front, which is what was preferred by the property owner. The area that Marty Shea is concerned about, which is the northeastern corner of the lot, is protected by buffer. And you should know the area of that naturally vegetated wetland non-disturbance, non-fertilization buffer totals 29,529 square feet, which preserves 68.8% of the overall lot. So I think the property owners come a long way to satisfy these concerns. It's notwithstanding our argument that we don't even think we should be regulated, but it gives everyone something. So my hope and prayer is that we can end this after this very long time and let these people proceed consistent with the plans that have been before you for quite a long time.
Thank you, Bruce. Marty, would you like to bring us up to date?
Yes. Good evening. I'm Marty Shea, Chief Environmental Analyst for the board. First, I would start by indicating that I cannot support the applicant's project plan, as the plan would yet impact two areas of freshwater wetlands at the site. One, as rightly described by the applicant, occurs in the east central portion of the property. The second is an area to the in the northeasterly portion of the lot that was filled. The survey that Karina Gorey has presented is actually a survey that was completed when the abutting lot owner to the east filed for a conservation board permit. And what it's showing on the subject lot, which abuts the west side of this lot, is again the centrally located freshwater wetlands, as well as an additional area of freshwater wetlands adjacent to this corner lot, which is in the northeastern corner of the subject lot. As described, these depressions are areas that have history, as this area is generally known as the Brick Kiln area. And the reason is that there are significant clays in the area, and historically, clays were dug for the purposes of transport to kilns for making bricks. And after the clays were removed, many of these pits or depressions remained with significant clay at their base, thereby allowing for ponding of water. Both the area in the east central portion of the subject property and the area that had been filled in the northeastern part of the parcel, they have been described in my advisory report of December 3, 2018 as vernal ponds. What vernal ponds are areas of ephemeral or seasonal flooding. They're areas that, particularly in the winter and spring months, can hold substantial amounts of water because of the underlying clays. But during the summer months and the fall, they generally dry out and may not have any ponding of water at all. These areas ecologically are extremely significant to amphibians and especially frogs and salamanders. They're very important breeding sites because they're generally fishless areas, so there are no fish to predate on the frogs and salamanders, nor on their eggs. So these areas also attract waterfowl. Oftentimes, if you have good rains and snow in the winter months and you have sufficient ponding, you'll have a pair of mallards or wood ducks that will take to these depressions and nest early in the year. Now, as alluded to by the applicant, yes, they are man-made, but they are not lined. They hold water because of the underlying clays, as evidenced by the recent test hole data provided by the applicant. And the town, as part of its wetlands law, regulates many areas of man-made wetlands, including dug lagoons and canals. So vernal ponds can be man-made. They're vernal again, because they not only hold standing water, but because you have prolonged periods of ponding, they support wetlands vegetation. In scanning the testable data provided by the applicant did find evidence of clays in the area filled freshwater wetlands in the northeastern portion of the property. The testable data indicated there was no evidence of wetland plants. Well, this is an area that has been filled for about 18 years now. So any plants, wetland, obligative, facultative plants that occurred in that northeasterly wetland historically, you would find little evidence of that today. I had originally been out there prior to the deposition and fill and grading of this area. And I had also been out there right after the area was filled. And my recollection is that accordingly, a notice violation and stop work order was issued in 2002. So ideally, my goal has been to not only protect the wetlands in the east central portion of the property, but also to restore those northeasterly wetlands. In the event that the board is hesitant about requiring the restoration of that area, I am trying to work with the applicant to make sure the project for design for the site covenants sufficient amount of area in that portion of the property in order to leave open the possible opportunity for future restoration of those wetlands in the years ahead. That is the reason why I just recently provided a sketch showing a recommended practicable alternative for the site that, in the interest of preserving that northeasterly quadrant and allowing for possible wetlands restoration in the future, the sketched alternative that I provided would position the house close to the northwest corner of the parcel. It would take advantage of section 330-83K of the building and zoning code. And what that provision allows for is essentially a 50% reduction in the required dimensional setback, side yard and front yard for the principal or primary residence, thereby allowing, without the need for a zoning board of appeals variance, thereby allowing for the shifting of the residence as close as 10 feet from the side yard and as close as 30 feet to the road. Now, the sketch that I offered for the applicant's consideration, which you're seeing before you, which obviously is just a rough sketch, does call for a one-car garage and storage space as opposed to the proposed two-car garage. It does offer a circular pervious drive in order to allow for additional on-site parking because of the reduction in the garage size. And it also sees an opportunity to expand upon the proposed deck area as offered by the applicant as well. Now, this sketch is not the only practicable alternative that could be considered. I provided that sketch because, again, my goal is to provide sufficient land area and buffering around that historic wetland area so that there would be the opportunity in the future to potentially restore that area without it posing any risk to the new residents on the property. And that, of course, would be achieved by excavating the fill back down to the clay layer. And again, allowing that area to seasonally flood and recover in terms of freshwater wetlands. A second alternative would be to basically work with the applicant's plan that calls for a 2-car garage, but still look to try and take advantage of section 330-83K to shift the house a little bit closer to Harbor Watch Court and to the westerly property line. Again, to set aside sufficient area in that northeastern quadrant to allow for a possible reclamation of the impacted freshwater wetlands. Otherwise, I'm in support of the applicant's project plans and purpose. I'm not looking to reduce the size of the house, with the exception of possibly a refinement of the garage footprint, nor am I looking to modify the deck and pool area, only possibly through expansion. So again, in summary, ideally, I would yet like to see the impacted freshwater wetlands restored in that northeasterly quadrant. But if the board is hesitant about requiring such reclamation, I just want to make sure the project is designed in a way so that sufficient land area is protected in that portion of property to leave open the ability to reclaim those impacted wetlands. Thank you.
Thank you, Marty. So the tension that I see here is, are there wetlands, or were there wetlands, more accurately, were there wetlands that were filled, as Marty has indicated, or were there not wetlands there? Michael, I would like to go back to something you said, and that is, you called an area in that northeast area of the survey a vernal pond. Did I hear that properly? Could you clarify that?
Michael Walsh never called it a vernal pond. I pointed out to the board there's no definition of vernal pond. This is not a vernal pond. This is a hole in the ground that was excavated, Marty's confirmed, by man-made clay mining in the Brick Kiln area for purposes of mining clay to make bricks. It is not a vernal pond. And our affidavits and the proof that we put in is supportive of that assertion. It is not a vernal pond. Absolutely not.
I believe Marty's testimony said that there were wetlands there that have been filled. Is that hole there now, or has that been filled?
No. That hole is no longer exists. It was filled. There was no wetlands at that location. There were never any wetlands, and there's no wetlands on the lot today. That's our position. We simply file this application, Mr. Chairman, quite frankly, because we've been tortured by this process since on or about 2002. It's the only reason that we're before you with this application. I don't believe there's a case in the town where the town has taken the position that an excavated hole that fills with water somehow becomes a wetland under our definitions in the code under 325, a vernal pond, a woodland hollow, or falls within any of these definitions. And we've
I live
taken a
on
lot
one.
of time to put proof in the record to that effect.
I live on one of those ponds. It was dug out by my uncle with a bulldozer. And then it turned into freshwater wetlands. And then Weesuck Bay ended up feeding into it. I'm looking at aerials of this property from the GIS page from 2001, 2004, and I could see those depressions.
You don't live on a hole dug for purposes of mining clay that is dry and is depicted in the photograph that we presented with our affidavits.
Dry
Absolutely
clay?
not. I refuse to
Dry
accept
clay?
that as evidence in the record. I'm sorry.
Dry clay?
It's a creek. It's a completely different habitat and wetland.
I'm not saying it was a creek. It wasn't a creek. It wasn't a creek. That's my point. And my point really is that a man-made hole dug can be recognized by DEC and this board as wetlands if there's wetland plants in it.
There's none here, and we've confirmed that, and that is clear in the record as well. And Mr. Shea has not pointed to one salamander, one frog, one animal, or one wetland plant at all in this record. This record is bereft of any proof that that's a wetland plant. These holes.
Behind the door in the hallway on the first floor. How about that? Michael, you indicated that there was a dug hole there that has been filled. Do you know when that was filled?
Approximately 2002.
If I may,
Yes.
just to correct a few things here. First of all, the test hole that Marty Shea refers to as positive proof isn't in the area he believes to be historic wetlands. All right, it's at least 50 feet west of that. Second thing, I was actually at this hearing or this court trial, and my recollection was Marty Shea couldn't testify what was there before, that although he put in an affidavit that he said he physically saw wetlands filled there on such and such a day, she does not mention to you, that was rejected. And he couldn't testify that in fact it was a wetland because he was never there. And as for the town's flagging of that area, the most recent one is Daphne Buckles, which occurs in 2007. And if the area was filled, what would she have been flagging? Some area of disturbance to rehabilitate a court case that was already lost. So our feeling is, you know, I can't tell you what was there before because I wasn't there either. But what I can tell you is that, you know, we've come to you in good faith to kind of resolve this thing after a very long time. And, you know, this notion that we can push the house to 10 feet from the side lot line, yes, it would comply with 330-83K. What he's not telling you is that no two-story building could be built 10 feet from a property line and comply with the town's pyramid law. So don't be deceived that moving this would comply with zoning. It would not. And finally, the circular driving for parking, first of all, goes over the septic system, which is not permitted. And number two, the town zoning code tells you you can't park in the front yard. Although I know people do, that is not a reason. So I hope that helps.
Can I just correct the record on the date, Bruce? The Daphne Buckles flagging occurred in November of 2005, and we put the survey in. The point there being that alleged wetland that we're all discussing here that was allegedly filled in wasn't flagged until A, the court case was disposed of, B, it had never been flagged before, and C, the alleged wetland was flagged well after it was filled. And it was flagged because the applicant had filed its first application, and all of a sudden, someone goes out there and flags this wetlands pocket on the street for the first time. So it was 2005, November 28th to be exact, 2005, when Daphne Buckles, who was then working for the town, we know, went out and flagged this particular area.
If I could just offer a few comments in response. The historic survey that you looked at actually showed wetland boundaries that were flagged back in August of 1998. So those wetland boundaries were marked prior to the deposition of Fell in that northeastern portion of the parcel. The wetlands along the the central boundary of the subject property that are depicted on the applicant's current plans. If you visit the property, you'll see that the area is fringed with the requisite wetland vegetation. I think it was predominantly woody species, but included some others. And so the area along the west central property boundary contains the requisite vegetation in order to be regulated as wetlands today. The area in the northeastern portion of the property, obviously that area is filled today. So it, of course, does not contain the requisite wetland vegetation today. But I can offer through my personal field observations prior to the deposition of fill in that area that that depression did indeed not only contain the requisite wetland vegetation to meet the statutory definition, but also was characterized by that seasonal flooding. In fact, the neighboring resident had indicated to me when that area was filled, the water was pushed down to the adjacent property, and he claims that that activity caused damage to his residence at that time. So it was certainly an area of seasonal flooding. The word vernal simply means ephemeral or seasonal flooding. And so vernal ponds or pools can be natural or they can be man-made, but they're only regulated as freshwater wetlands pursuant to Chapter 325 if they contain the requisite wetland vegetation. And although that area is buried under fill today, it did contain requisite wetland vegetation prior to the fill activity. With regards to the applicant's test hole data, the finding of clays, even if it was not within the immediate location of the formerly flagged northeasterly wetlands, indicates that this is an area of substantial clays, and that if you dig a pit to a sufficient depth, you're likely to reach those clays, and if that pit is left open, that area will seasonally flood, and it's that seasonal flooding that gives wetland indicative vegetation the competitive edge over upland vegetation. So in time, those areas support sufficient wetland vegetation so that they can be regulated pursuant to the town code. Thank you.
May I respond to that briefly, Mr. Chairman? First of all, Marty's testimony with respect to wetlands vegetation existing in these dug holes, okay, is clearly incorrect. Why do we know that? There are three alleged wetlands, according to Marty, on this survey. 3 different depressions. One we've spoken about has been filled as early as 2002. So he couldn't have observed wetlands vegetation in that. Why do we know that? Because the other 2 depressions consist of the same excavations. There's no wetlands plants in those holes either, and there's nothing in the record whatsoever to tell us, either from Bruce Anderson, Sean Barron, or Marty Shea himself, besides what he said today, that there's any wetlands plants in the other 2 man-made dug holes. So what he's saying is, of the 3 wetlands areas that we're talking about, there's only one that contains wetlands vegetation based upon his testimony that he saw it there prior to 2002. That testimony is completely irrational on its face. There's no wetlands plants here. There's no proof in the record that there's any wetlands plants in any of the 3 depressions that we're talking about. How is it that he can testify tonight that he saw wetlands plants sometime prior to 2002 before this area was filled? That's irrational on its face. There's no wetlands plants on this site whatsoever.
If I may, Marty Shea, Chief Environmental Analyst for the town. The application before you is not a wetland determination appeal. If it was a wetland determination appeal, as the applicant and board knows, I would prepare the necessary technical report that would describe the on-site wetlands, describe the on-site vegetation, and indicate how that was used in making wetland determinations. I agree that in the northeastern portion of the property, there is no evidence of wetland vegetation there today, nor is there an ability at this point in time for me to prepare a detailed technical report describing in detail the wetland vegetation that once occurred and that I personally observed in that area. That's the reason why my office had previously flagged that area as wetlands, because we found the requisite vegetation. Recognizing the difficulty in describing in detail the technical conditions in the northeastern portion of the property, I am not opposed to the applicant's plan. The only concern that I have is that the applicant's plan shows the new residential improvements a little bit closer to that area of historic wetlands, that historic depression in that northeastern corner. Then ideally I would want, as my interest is to leave open the opportunity possible reclamation and recreation of those wetlands in the future. So I just recommended that the applicant consider as a practicable alternative a minor refinement of their plans and a minor shifting of that residence for discussion purposes. We would never recommend that a driveway be built over the entire sanitary system. Typically, through issuance of variances, the Suffolk County Department of Health Services only allows for the septic tank to be under the drive. So I, of course, am not asking that a drive be built over the existing septic system, over the planned new septic system. I actually have not testified in court regarding the outstanding litigation. And there are two lawsuits that are outstanding related to this property. The applicant did correctly say that I did provide supporting affidavits that are part of your record. So the applicant's plan does call for establishing a covenant over the area of historic concern, and also over the area along the easterly property boundary and the southerly property boundary, sufficient to protect those areas that haven't been impacted as those existing seasonally flooded depressions are regulated wetlands, and they are so critical in terms of wildlife habitat. I had only asked that the applicant consider shifting the residents in the future. So if the board decides to support the applicant's plan and close the hearing and proceed with a resolution of conditional approval, I would just ask that the covenant language leave open the possible future opportunity to reclaim that area if indeed future owners of this property are so interested in working with the town with regards to wetlands recreation and reclamation. Thank you.
So, Michael, or perhaps Bruce, if you look at that plan, what Marty's asking is that there be more space left in that area of that filled hole, if you will. Does that work for you to?
We don't want to dig another hole, Mr. Chairman, in the front yard of our property. That's what Marty means by reclamation, I believe. To dig another hole. We don't want to do that. It's going to be dangerous. My client has a lot of grandchildren. We don't want a kid falling into a hole full of water. The ones that are in the backyard, by the way, are equally dangerous. Just in case you wanted to take a look at these are holes in the ground. They're ditches, they're holes. Sometimes they fill with water, not fill. There's some water in the bottom. Most of the time they're dead dry, like today. But we don't want to dig a hole in the front yard. Absolutely not. I mean, that goes to the value of the property. It destroys the property. This property is going to be an aberration on the street front if you drive by, because everything's going to be squeezed into one corner of the property. And quite frankly, everything we possibly can. As Bruce described, that average buffer is over 125 feet at this point. We've given over, 66.8%, I think Bruce said during his testimony. We've dedicated, 68.2%, excuse me, of the property. That leaves us a third of our lot. That's it. Anything more is just punitive, quite frankly.
Can we put up a side-by-side between the proposed by Marty and the applicant? I just have a couple of questions when I look at this proposed survey by the applicant in terms of, hold on, there you go.
I think I can do a side-by-side, but I'll put it.
Well, my question is, so where the garage is, and there was a proposed gravel that's crossed it out to relocate proposed gravel driveway, and it was moved over to the left, it looks like. Is that correct, Mike and Bruce?
That is correct. That's what our new plan shows. It's consistent with that plan.
All right, hang on. So, I mean, I look at this plan, and I think it is a better plan and the best plan for this property, being that that northern hole was filled in. I don't see a benefit of revisiting that. I think the buffer zone that you prepared does make sense. It is giving up a lot of the property. I'm not a fan of putting something 10 feet off a property line when we're the conservation board and not the zoning board. So I really don't think this is a horrible plan that they're proposing based on what they're giving back in terms of this non-disturbance fertilization buffer, non-fertilization buffer. And moving that driveway over, I think makes sense.
Just for clarification purposes, Karina is not currently showing the applicant's latest plan. The prior plan was a marked up plan. This is a rough sketch that was done by my office. The survey is a later survey, correct, Mike, that you're describing.
If I may, can you just put up the survey that is before you? That is
That's
this
what,
application?
That's what I'm trying to get done right now. Yeah, I'd like to see that current survey as well. Bruce or Mike, do you have any ability to hold that? Hold on, I think I found the survey. Yeah, the survey was received in December of 2000.
We're going to scan it and send it to you right now, and you can put it up. How's that?
Yeah, send it to Karina.
I'll take an email of it, even if you can't get it up.
But we should be able to, I think it's important to show it as visual for the
Can we
board.
put it up here? We might be able to do it here, so let's see what we can do. The point is, we did that for settlement purposes, Michael, just so you know. That driveway was moved. That's why I said in my opening statement, we're not entering.
I get it.
Okay.
I can actually hold it up, and you can let me know if you can see it sufficiently.
Yeah, that's
the one.
that's what I was discussing.
All right, we got it. Let's send it to
Hold
him.
on. I'm going to share it. Hold on. Let me share this.
Share it with Karina.
Hold. Let me see something.
Yeah, that's correct.
You guys see that?
Yep.
Okay.
Yeah. So you see what I'm saying? We made those changes already. And the other thing too is, if the statement is that, oh, the test hole doesn't have to be near the historic area, but it tells you it's clay, why, if a future, I think what he said was, Marty said, was that he wants the covenant to provide the right to dig a hole if you want, which I think any covenant would. And so if the...
I don't think you can dig holes. I'm sorry, Bruce. You can't dig holes. If you have a non-disturbance buffer, you can't go out and dig a hole in the middle of it. You cannot. Under the
I thought what he was saying was that if a future property owner wanted to dig a hole, that the covenant wouldn't prevent a future property owner from doing so. I can assure you, the current applicant has no desire to dig any holes.
Bruce, your description is correct. That was my intent. I know that the current landowner has no interest in excavating any portions of the property and creating wetlands. I think you're correct in that the covenant, as long as there's no prohibition on excavation, would allow for such reclamation in the future. But you know, I just may have an interest in looking at the current language and seeing if that language could be, if necessary, refined a bit in agreement with you to allow a future owner to excavate to create or recreate wetlands.
And I guess
as long as it wasn't mandatory, I could discuss that with the client. As long as it wasn't mandatory, I don't see why giving a future owner the ability to do that would be problematic as long as it wasn't mandatory.
No, I am not, at this point in time, recommending that it be mandatory with regards to the current landowner. Absolutely not.
Then I would recommend that there be no objection to that type of a provision. I would recommend that to the client.
It sounds like we have a plan.
Yes, sir.
Do we have any other board members that have questions?
No.
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 Is there anyone in the public who would like to speak in this application? And Charlie, I don't think there's anybody
None.
there, right?
I see none.
Okay. I would entertain a motion to close this hearing.
So moved.
Second.
All in favor? I don't have a picture of all you guys anymore in right order. All in favor, say aye. Harry, aye. So whoever wants to speak up, there we go.
And aye.
Tom, aye.
Aye.
George, you've muted yourself. You don't unmute yourself, George.
And Jerry,
Unmute yourself.
Jerry, did you vote?
Aye.
And George is here with us?
Yes, but he's mute, like Helen Keller.
Don't you wish?
Now he's not.
Aye.
Okay, thank you, Michael. Thank you, Bruce. Thank you, Marty.
Thank you very much for your time.
Thank you.
And thank you, Sean. Now we can have Kelly come back. I don't know what the method is to let her know that she can come
I
back.
just emailed her.
Okay. So the next application is A190012, Janice Myers, and the application is withdrawn.
Kelly's muted.
Back on.
So with Janice Myers, the application is withdrawn, and we have a resolution to withdraw later in the agenda, so we'll just move on. A190082, Rawson Road Association, Inc., and the applicant requests an adjournment to 9/23/20. First, let's see, it has not been opened.
That was opened at the last hearing.
Oh, okay, so it's open but not heard.
Right.
Is there anyone in the public who would like to speak on this application? And, Charlie, I'm assuming it's still the same, there's no one there. Is there a motion to adjourn
That's
to,
correct.
can we adjourn to 9/23? Do you have space on that date? (9/23). 1, 2, 3, 4. Yes. Is there a motion to adjourn?
So moved.
It's been seconded. Harry, aye. Michael? Jerry?
Michael, you're muted.
And Sunshine, I saw you vote. Tom?
Sorry.
Aye.
And Ann?
Aye.
George?
Aye.
A020010, MIR Noyak Realty LLC. The same as the last application. Is there a motion to adjourn to 9/23?
So moved.
Second.
All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine? Aye. Tom?
Aye.
Ann?
Aye.
And George?
Aye.
Move on for the advisory reports. Ocean Park, map 559.
All right, good evening again. Marty Shea, Chief Environmental Analyst for the town. This is an old file map amendment application. It's currently pending before the planning board. There are several recommended comments in the draft advisory report before you. The subject property is located in the hamlet of North Sea. The first comment simply offers that the applicant is seeking approval to amend an old file map in order to reduce the length of the required improved portion of the road known as Broadway, as well as to shift Broadway's intersection with Edgewood Woods Road to the east. And that's being done in order to increase the line of sight distances. Second, the track is located greater than 200 feet from any town regulated wetlands. As such, development of the lots is eligible for a letter of non-jurisdiction pursuant to Chapter 325. Thirdly, the draft report indicates the track is located within the town's Aquifer Protection Overlay District. Accordingly, development of the future residential lots would be subject to the site disturbance and clearance standards as set forth in section 330-67A, which of course is protection of natural vegetation. And lastly, the planned reduction in the length of improved road will allow for better preservation of mature woodlands and steep slopes while reducing the area of impervious surfaces within the town's Aquifer Protection Overlay District. As such, the Conservation Board supports the plan map amendment.
Motion to send those comments to the planning board.
Second.
All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine? Sunshine?
Oh, aye. Sorry.
Tom?
Aye.
Ann?
Aye.
And George?
Aye.
1206 Flying Point Road LLC.
Back up.
Thank you, Skip.
Sorry, I missed one. Almonds LLC.
Okay, this pending variance application before the Zoning Board of Appeals for a property on Bayview Drive East in the hamlet of Noyak. You'll note on the agenda, you also have a pending Conservation Board wetland permit application for this parcel. The applicant has a plan to redevelop this site. So the first comment simply indicates that the applicant is seeking rear yard and pyramid variances, again, in order to demolish the existing dwelling and construct a new residence with patio and swimming pool on a parcel of land with frontage on Saco Cove that contains town and state regulated tidal wetlands. Second, describes the pending wetland permit application before you. It indicates it was received on February 11, 2020, and that in response, the board had sent out notices of incomplete application. Thirdly, the draft report indicates that additional information was received by the board on July 23rd, 2020, and that there is significant public interest in this application. Accordingly, later in the agenda, you'll have a recommendation that a public hearing be scheduled for the pending wetland permit application. And lastly, is a recommendation that any decision on the pending variance application be postponed till the Conservation Board has held a hearing on the pending wetland permit application, as project modifications may be required as a consequence of that hearing and any conditional approval that's granted by this board.
Question, procedurally, chicken or the egg, should we schedule the hearing before we act on sending the recommendations, or?
Yes, I would make sure that you schedule the public hearing first and then just go back to adopt the recommendations after.
Okay, so let's table this until after we schedule the hearing. I'll move on to 1206 Pine Point Road LLC.
This application relates to a property in the hamlet of Watermill with frontage on the Atlantic Ocean. The report indicates that the applicant is seeking variances from the required dune crest, side yard, and total side yard setbacks, as well as height and pyramid variances in order to demolish the existing dwelling and accessory improvements and construct a new residence with accessory structures. The second comment offers that the planned redevelopment is separated from the nearest town regulated wetlands by a paved road. As such, my office issued a letter of non-jurisdiction pursuant to Chapter 325. Thirdly, this comment indicates that the Conservation Board has significant concerns regarding the planned, the requested dune crest setback variances. It indicates that the town has established a minimum 125-foot dune crest setback, and that's in order to preserve the natural protective features and protect new structures from coastal storm damage. The Conservation Board recommends that the applicant explore practicable alternatives, such as alternative septic designs, which would eliminate the need for retaining walls and also allow the dwelling to be sited further landward of the dune crest. And lastly, as is standard for these draft advisory reports, there's a comment that simply indicates that notwithstanding the issuance of a letter of non-jurisdiction, no determination has been made with regard to the compatibility of the requested relief with the other variance issuance standards as set forth in the town's building and zoning code.
Motion to send those comments to the planning board.
Second.
To the ZBA, sorry.
Second to the ZBA.
All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George?
Aye.
The administrative wetland permits are in your packets. Move on to resolution of conditional approval. A019104, 19 Shinnecock Road LLC. Any discussion?
Move to issue.
And do I hear a second?
Second.
Resolve that a conditional wetland permit approval be granted to 19 Shinnecock Road LLC for the proposed project by the terms and conditions set forth therein. All in favor? Harry, aye.
Aye.
Michael? Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
And George?
Aye.
A020029, Itai Shoshani. Any discussion?
Move to issue.
Second.
Second.
Resolve that a conditional and permit approval be granted to Itai Shoshani for the proposed project by the terms and conditions set forth therein. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George?
Aye.
A020039, Job's Lane LLC. Any discussion?
Move to issue.
Second.
Resolve that a conditional wetland permit approval granted to Job's Lane LLC for the proposed project by the terms and conditions set forth therein. All in favor? Harry, aye. Michael?
Aye.
Jerry? Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George?
Aye.
Preliminary review secret determination, A019131, Patricia Lynn, Prue Revocable Trust.
Morty Shagan, Chief Environmental Analyst for the town. This application lists an existing residentially developed property that has frontage on the Little Peconic Bay. The property, as you can see on the aerial photograph, contains beach and bluffs, which are mostly armored with gabions that were installed prior to the effective date of Chapter 325. The applicant is seeking approval to armor the remaining section of shoreline where there are eroding bluffs. This is an application for which significant additional information is needed in order to make a determination. As such, I'm recommending that a public hearing be held.
Motion to schedule a public hearing,
Second.
For what date?
October 14th, 2020.
Resolved that the Town Conservation Board hereby schedules the public hearing for October 14th, 2020, and the notice of public hearing be published in the town designated newspaper pursuant to Chapter 325, Section 325-8C of the Town Code. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
And George?
Aye.
A020043, Jonesford Investments Limited, the applicant requests postponement to 11/18/2020. Is there a motion?
Postpone.
Motion to postpone.
Second.
All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George? A020009, Almonds LLC.
This application again relates to a property where residential redevelopment is planned along Sag Harbor Cove. You're seeing the applicant's project plans. You'll note that the cove frontage is bulkheaded. There is an area in the southwestern corner of the property where you have naturally vegetated tidal wetlands that extend along the return landward of the main cove fronting bulkhead, in the interest of having the survey depict all regulated wetlands. I did have an opportunity to flag the wetland boundaries in that area, and I've asked that the applicant survey be revised to show those boundaries. There is a preliminary advisory report on file dated August 24, 2020, in which I'm asking a slight modification to the proposed covenanted naturally vegetated wetland non-disturbance, non-fertilization buffer, in that, again, in that southwestern corner of the property. This is an application for which there is a significant public interest. I have been contacted separately by both abutting residents who have lots of questions and concerns regarding both the pending wetland permit application and, as previously described, the pending variance application before the zoning board. So in light of that degree of public interest, I am recommending that a public hearing be held.
Motion to schedule public hearing on October 14th, 2020.
Second.
Second.
Resolved that the Town Conservation Board hereby schedules the public hearing for October 14th, 2020, and that a notice of public hearing be published in the town designated in the favor of person to chapter 325, section 325-8C of the town code. All in favor? Harry, aye. Michael? Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George?
Aye.
And let's scoot right back to
One more.
the almonds one under ZBA. We want to pass that before. Is there a motion to send the comments to the ZBA concerning Almonds LLC?
So motion to send the comments.
Second.
All in favor? Harry? Aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
And George?
Aye.
A 020042, Michael DiStefano and Lisa DiStefano.
This application relates to an existing residentially developed property in the hamlet of Shinnecock Hills. As you can see, the property has frontage on Old Fort Pond. The application has been made because the landowner is interested in elevating the existing residence and constructing various additions to the dwelling as well. As indicated on the survey, in addition to the bulkheaded tidal wetlands along Old Fort Pond, there are unbulkheaded wetlands down a dirt road to the northwest of this property. The closest setbacks from those wetlands are shown on the survey. I have recommended that a 20-foot wide naturally vegetated wetland non-disturbance non-fertilization buffer be established along the pond fronting bulkhead, which is consistent with this board's policy for other similar bulkheaded lots. This is an application for which we have sufficient information to make a determination. As such, I'm recommending that the public hearing requirement be waived.
Motion to waive the public hearing.
Second.
Resolved that the Town Conservation Board hereby waives the public hearing requirement pursuant to chapter 325, section 325-80 of the town code. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine? Tom?
Aye.
Ann?
Aye.
And George? Resolution to issue modification, CB 15-00019, 118 Dune Road Realty LLC. Any discussion?
Move to issue.
Second.
Resolved that a wetlands permit modification be issued to 118 Dune Road LLC, Dune Road Realty LLC for the proposed project and for the terms and conditions set forth therein. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George?
Aye.
CB 16028, Dennis M. Brophy and Patricia E. Brophy. Any discussion?
Move to issue.
Second.
Resolve that a wetlands permit modification be issued to Dennis M. Brophy and Patricia E. Brophy for the proposed project on the terms and conditions set forth therein. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
Aye.
George? Resolution to withdraw A 190012, Janice Myers. Is there a motion to pass the resolution to withdraw, to accept the withdrawal?
Motion to accept the withdrawal without prejudice.
Second.
Resolve that the Town Conservation Board hereby accepts the withdrawal without prejudice of wetlands permit application number A190012. All in favor? Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
Aye.
George?
Aye.
And now resolution of denial, A019055, Cold Mountain LLC.
Marty Shea, Chief Environmental Analyst for the town. This is actually pending wetlands permit modification application. This property in the hamlet of Shinnecock Hills that fronts Shinnecock Bay. It has a beach and a bluff as well. Landward of the crest of the bluff, the property is extensively cleared and landscaped. The applicant is seeking to redevelop this property. The Conservation Board had adopted a resolution of conditional approval on July 24, 2019. Actually, to correct my prior testimony, the applicant is seeking a modified conditional approval, not a modified wetlands permit. When the conditional approval was granted, as is customary for a larger lot like this, it was conditioned upon establishing a covenanted, naturally vegetated wetland, non-disturbance, non-fertilization buffer, extending 75 feet landward of mean high water in the wetlands boundary on this property within the portions of that buffer where you currently have a fence line, an existing mowed lawn. The board had asked that that area be revegetated, and it asked that it be revegetated to coastal woodlands, as are characteristic of bay-fronting properties in this area, and as currently occurs on the abutting lot to the west, as described in the original advisory report and in communications with the applicant. The goal was to create more of an open woodland with some pitch pine and post oak, and then to have extensive open areas of native Pennsylvania sedge, have some bayberry, shad, highbush, blueberry, as is characteristic of these habitat types. After the conditional approval was granted, the applicant's agent went back to the landowner, and the landowner said he has no interest in planting any trees whatsoever as part of the required revegetation. The recommendation for restoration of coastal maritime woodlands in this area is consistent with recommendations that are made in these cases, and it was to offset or mitigate the wetland impacts. Upon receipt of this application, I went back to the property and found that after the new landowner had purchased this property, he recently topped and cut woody vegetation on the bluff down to about 3 to 4 feet, inclusive of black cherry, beach plum, and other mature vegetation. While the property was characterized by some cut woody vegetation on the bluff face when the applicant recently acquired this, the applicant was advised that no cutting was permissible in that on that bluff face. So because the applicant is not interested in abiding by the mitigation conditions that were placed on the conditional approval. And because the applicant has done significant unauthorized cutting and has also discarded those cuttings down the bluff face. They're
Nice.
stacked on top of pre-existing landscape debris that the applicant was also required to remove pursuant to the conditional approval. For those reasons, I had advised the applicant upon receipt of this application that if they still desired a public hearing in order to seek significant relief from the conditional approval, that they should file a new Conservation Board wetland permit application. The applicant has decided to await the decision of this board. So I had indicated to the applicant that I was recommending a denial and described the reasons why I was recommending a denial of the request for the modification to the conditional approval. I should also mention that the request is also being made to allow for construction of an environmentally compatible bluff access stairway down to the beach. I have no issues whatsoever with building that stairway. It is the refusal to properly restore the required buffer area, and it's because of the ongoing unauthorized cutting and discard of landscape debris that I'm recommending that the application for a modified conditional approval be denied.
Motion to deny the applicant's request to modify the July 24, 2019 resolution of conditional approval and we should advise the applicant or direct him to file a new Conservation Board wetlands permit application in order to allow for reconsideration of the proposed activity.
Second.
Resolved that the Conservation Board denies the applicant's request to modify the July 24, 2019 resolution of conditional approval, and be it further resolved that the applicant is directed to file a new Conservation Board wetlands permit application in order to allow for reconsideration of the proposed activities. All in favor? Harry, aye. Michael?
We should deny more of these. Aye.
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann?
Aye.
George? Is there a motion to go into executive session for the purpose of discussing litigation?
So moved.
Second.
There's a second?
Second.
Sunshine.
Harry, aye. Michael?
Aye.
Jerry?
Aye.
Sunshine? Sunshine?
Aye.
Tom?
Chairman, you might want to advise as to whether or not you plan on going back into the meeting after the executive session. If there is no business to tend to within the context of the meeting, you may be able to adjourn the meeting at this time and simply go into the executive session. As Kelly has indicated, the executive session will be conducted by conference call, not by Zoom.
Thank you, Marty.
Okay. So,
You could make a motion to just adjourn the meeting. And then we'll do the executive session by phone call.
okay.
Should we include the executive session in the motion?
Yeah, let's make a motion to adjourn the meeting and follow up with a conference call for executive session with an executive session for the purpose of discussing litigation.
Motion to adjourn the meeting and then to enter into executive session for the purpose of discussing litigation, for which we will not return to Zoom after.
Harry, aye. Michael?
Is that seconded?
Jerry?
Aye.
Sunshine?
Aye.
Tom?
Aye.
Ann,
Aye.
and
Aye.
George.